I am a short cisgender female with pixie cuts and wearing a gray sweater and a white shirt. Today I am joined by my colleague, Ashley Craiglow with the Arrowhead Area Agency on Aging. We would like to welcome you and thank you for joining us for today's session on power of attorney. Before we get started, we have a few items to go over. Ashley, want to click? We're excited to announce that today's webinar will be accessible to a wider audience. We have arranged for American Sign Language interpreters who will be present during the session. These interpreters will rotate about every 20 minutes, ensuring that everyone can follow the content effectively. Additionally, we are recording the entire webinar with ASL interpretation, and these recordings will be available on our YouTube channel for later viewing. So if you've got someone who you know would have liked to have joined us for today's session, you can go ahead and we'll send out the link and you can share that with folks and they can check that out when they've got time. So whether you attend a live session or catch up later, you'll have the opportunity to engage in the material in a way that suits your needs. I encourage you to subscribe to our YouTube channel so you can keep up with the latest additions to our video library. We are always looking for suggestions for topics for future webinars. So if you've got suggestions for topics or speakers, you can please feel free to send those to the email, which we will share in the chat. Logistics, please keep your microphone set to mute. Just a note, if you do experience any issues with your video quality or audio quality or bandwidth, it often helps to disable your camera. If you'd like at this time, you can enter your name and what community you're from in the chat box. If you have any questions during today's session, please feel free to enter your questions into the chat and we can address them at the end of the presentation. We'll also take some additional questions at that time. At the close of today's session, you'll see a quick evaluation of today's session pop up in your browser. Please take a moment to complete that survey. It helps us greatly when planning future sessions. And one last reminder, you visit our Facebook page for more information about other upcoming sessions. We've got ones coming up, additional ones talk about advanced planning, still coming up this week. Next month, we have one on long-term care staffing. You can also check out on our website at arrowheadaging.org. Next slide. So a little bit about us at the Arrowhead Area Agency on Aging. The Arrowhead Regional Development Commission is designated by the Minnesota Board on Aging as the Area Agency on Aging for the Planning and Service Area under Title III of the Older Americans Act. The Arrowhead Area Agency on Aging is committed to helping older adults maintain their highest level of independence. Area agencies on aging are regional organizations that provide services, support, and information for just about everything that older adults and their families might need. Minnesota has 7 area agencies on aging across the state that are local connections for older adults and the community supports they might need as they age. The Arrowhead Area Agency on Aging's planning and service area, as designated by the Minnesota Board on Aging, includes the counties of Aiken, Carlton, Cook, Itasca, Koochiching, Lake, and St. Louis counties. Next page, next slide. Next, I'm going to take a moment to read our land acknowledgement for the Arrowhead Area Agency on Aging. As we support our mission to help older adults maintain their highest level of independence, we do this while being respectful of the space that we are being welcomed into by Indigenous people. We strive to deepen our understanding of the multiple ways in which people see and understand land and acknowledge the Indigenous people who have relationships with this land. We also acknowledge the decades of historical trauma, loss, and grief experienced by Indigenous people. It is our promise to not only recognize these truths, but also take action to show support of our Indigenous elders, neighbors, and friends, and understand our place within the past, present, and future of this land. We know this is just one step in recognizing and honoring the sovereignty of tribal nations. So we are honored to have with us today one of my favorite colleagues, Kristin Parendo with Justice North. Kristin is the elder law lead attorney with Justice North. You may have known Justice North in the past as legal aid services for Northeastern Minnesota. And Kristin specializes in elder law and has for over 20 years. She graduated from the Mitchell Hamlin College of Law in 2001 and lives in her childhood hometown of Esco, Minnesota, where she and her family raise cows and chickens for fun. Kristin, thank you so much for being with us today, and I'm going to turn things over to you.
Thank you very much, Brenda, and thank you everybody for attending today. If there's something that we don't get answered for you today, or please feel free to reach out to me on your own if you like. You'll have my contact information at the end of this presentation. It'll be on the slide. So let's go to the next slide. A little bit about Justice North before we jump into our topic of power of attorneys today. We're a nonprofit private law firm serving 11 counties in northeastern Minnesota. 7 of those are greatly helped with funding from the Title III Older Americans Act, which means that we can help people that have more income than we normally could under our other funding. So what that means is if you have somebody who is 60 or you yourself are 60 or older and live in our service area, please call us, because there's a very good chance that we can at least have a conversation and give you legal advice. If you have a lot of assets and income, we're going to probably limit it to advice, but if it's something that falls into our priorities, we can also represent you in administrative hearings, civil court, other things like demand letters to third parties, that sort of thing. Our main goal is to bring equal justice to as many people as possible. All right, next slide. And here is our service area. You can see it's pretty large, 11 counties there. And all those stars on there are the locations of our physical offices. My physical office I'm tied to is Duluth, but I actually work out of my home office most of the time. We travel to go to places that need us there. If we have a homebound client, for example, or if there's some outreach or an event that we would like to attend, we do that as well. All righty, let's go to the next slide. All right, so this is what we're going to talk about today, advanced planning with a power of attorney. This is a key part of advanced planning, and we're going to cover these topics: what and why, what the heck is advanced planning, and why it can help you now and throughout your life as we age, who should do it, who should have a power of attorney, who are the people that would make a good agent for yourself. In the power of attorney, you'll see I'll use the term attorney in fact. That's just a term of art that is used for this document. It doesn't mean an attorney. It's just the person that you've selected to step into your shoes. We're going to learn how to use the power of attorney. We're going to look at one. We're going to see what is a good, what you need to fill out on a power of attorney, what decisions you need to make. And we can talk about how it can meet your goals for your financial and property matters. Let's go to the next slide. Okay, so going back to first principles, what is advanced planning? It's planning so you get to have the life that you want as much as possible. And you do it by putting it in writing. Because if you don't put stuff in writing, as we all know, when you can't speak for yourself, things can go in a different direction than you would want it to go. So you can put your goals and instructions in writing. You can name people that you've talked to in advance, hopefully, and they're willing to act, so they can make sure that your goals are accomplished as much as possible. So you keep control. So if you don't have a power of attorney, what happens usually? So a power of attorney you use to control financial and property matters. So if you don't have one and you become unable to act for yourself, what would happen is that a family member typically would have to file for something called a conservatorship. And And that's where they petition the court to become the conservator. And the court would have to make a decision. Number one, do you lack capacity? And second, who would make a good conservator for you? And it's not necessarily the person that you would have chose yourself. So it's best to avoid the need for a court to look into your life by setting things up ahead of time. Let's go to the next slide. As I said, why you want to do it? Keep control of your life. When you can't communicate or understand what's going on in your life as much as you would. When you share your own authority to act, you're not giving anything away. You're sharing your authority. So it's not that your people that you name can now make decisions for you. They can't do it willy-nilly. They have to do it according to your wishes. And if they don't know what you want, they have to act as a reasonably prudent person would in the same situation. So it's good if you could talk to the people that you're thinking about naming to see, number one, what are their thoughts about doing it? Are they able to do it and willing to do it? And will they do what you want to do? Do they have anything that is tempting for them? Do they have any monetary stressors on their life? Think about all those things. We'll get into that more. But the power of attorney is a legal document which comes with some enforcement powers. So if your power of attorney doesn't act the way you want them to act, you've got some ways to force them to act. You've got some ways to revoke it. If your power of attorney is trying to do something for you and a third party, like a bank, isn't doing what you want, there are some enforcement powers that your person can do. So it sets into place powers that your person can use for you. As I said again, you avoid conservatorship. You have more privacy because there's no court involvement, more freedom. And probably the most important, it makes it easier for your loved ones to act for you when you need them to act. It's similar to a healthcare directive in that extent. It's a gift to your family. So you're giving them the power to help you. And if you talk about things, you're giving them the knowledge of what you would want in certain circumstances. All right. You can see on the slide there on the right-hand side, I put a little box. That's kind of like a quick way to know why, whatever the slide topic is, you can look at that slide and you can get the information quick and easy. You'll see it on the rest of the slides as well as we go ahead. I believe the slides will be available to you after, so you can refer to them. All right, let's go to the next one. So who should do a power of attorney? The short answer is everybody, because everybody has stuff, money, at least some. Everybody has private information. Without a power of attorney in place, if you weren't able to handle your affairs, nobody could do it for you. They can't write a check for yourself. They can't talk to, say, an insurance company about your policy, anything like that. So if you have a power of attorney, it's a wonderful tool for your person to act for you. So everybody should do it, 18 or older, any adult who has capacity. Before we move on, so what is capacity to have a power of attorney? So as you probably know, each legal document might have a different level of capacity. For power of attorney, it's the same as the capacity to contract. So what that means is, do you know the nature and extent of what you're doing by signing a power of attorney? So if you know that by signing this power of attorney, I'm allowing somebody to step in and handle my financial and private information, then you would have capacity to do a power of attorney. Speaking of capacity, sometimes people have capacity one day, sometimes they don't have as much the next day. It can fluctuate over time. That does not mean you can't have a power of attorney. Doesn't mean that you can't do one. You can take a power of attorney document and fill it in chunks. So if you've got capacity, say in the morning, you can fill it out in the mornings and then go back to it later on, a few days later, in another morning. You can do that however long it takes you to do it. And then, because everybody legally has capacity until the court says otherwise. But we all know that has some gray area. So if you think that somebody's going to challenge your power of attorney by saying that you didn't have capacity, you could go to your doctor and get the doctor to write a letter for you saying what they think your legal capacity is. And then that would be in your papers should your power of attorney have to fight back a little bit. But bottom line is, if you've got capacity, you can do one, and capacity can fluctuate. All right, let's go to the next slide. So it's important for everybody, but it's especially important if you fall into one of these 4 categories. You should have one if you're unmarried, because you don't have a spouse that typically people will go to. That's not to say that spouses will get automatic access to anything anyway. So it's good for married people to have power of attorney as well. But sometimes things happen informally. If you don't have a close family member or you don't want family to control your financial and property matters, then you should have a power of attorney naming who you would want to do it. If you're in a second marriage and you have children from the first marriage and you want your current spouse to have power, you definitely want to have a power of attorney in writing, because that will bolster your spouse's ability to act for you in the face of maybe some first children fighting your partner. So get those documents in place for your second partner to act for you. And finally, if you've received a diagnosis that it's going to be chronic or a progressive diagnosis where your capacity might be at issue, for sure you want to get a power of attorney. All right, let's go to the next slide. So how do you draft one? We're going to cover these things. This is the main things about a power of attorney. And I figure if I talk about them more, they'll stick in your head more. So there's two types of power of attorneys. There's a statutory short form, and then there's a common law. Don't get hung up on the terms. Statutory short form just means that the legislature made the form and they actually put it in statutes, chapter 523. So you could go to that chapter and get the form from there if you wanted. You can get the form from the Department of Commerce, Minnesota Department of Commerce. You can get it from our legal aid coalition website, and lots of different places. The other version is, we call it a common law version. That's not the official title. That just means that it's come up through time in common law to what we mean by a power of attorney. So you're naming somebody to act for you, but a common law power of attorney just means you're not restricted to the form of the statutory short form. We'll see as we go, the statutory short form has some restrictions to it, which if you don't want to be tied to those restrictions, you can also have the common law power of attorney. If you have a lot of assets, you might want to have a common law power of attorney as well. So your person has the maximum ability to act for you. You can choose your people, choose what powers to share with them, choose what kind of safeguards you want to put in place just to make sure your people aren't going to misuse their power, and then you sign it correctly. And we'll see all those things as we go forward. Let's go to the next slide. Remember, you do not need an attorney to draft this. haven't said it yet, but I want you to know there's nothing magic about having an attorney to draft your power of attorney. It is nice though, because then an attorney can answer your questions, but you don't technically need an attorney to draft it. And you can see here's the box on the right hand side with more of the things about the power of attorney. You can find it in chapter 523. The thing about a power of attorney, statutory short form power of attorney, you don't cross things out on there because then you take it outside of the chapter, which doesn't necessarily make it invalid. It's not invalid, but you don't get the enforcement statutes that go along with it. So don't cross things out and don't write things on the side. If you want to do that, have a common law power of attorney. Statutory short form is the most used in the state. It's recognized by everybody. People use it in all different circumstances. We're using it in a advanced planning situation, so it's with the goal of putting into place and then keeping it into place until you pass away. As I said, it's enforceable through the statutes, including a protective order if your person isn't doing what you want them to do. You can have both kinds of times. I can speak both types at the same time. Common law is useful if you don't want to be limited. All right, let's go to the next slide. Okay, we're going to look at the actual power of attorney, but I want to just talk about the main parts of the power of attorney ahead of time so you know what you're going to look at. And I know I've talked about this already a little bit, but each time we do it, it might be easier to remember. First, it's your document, so there's going to be a spot where you identify yourself, typically your name and address. Never put social security numbers on legal documents because you don't know who's going to be looking at your document in the future. All you need is your full legal name, your address. You're going to pick your people. They're called attorneys in fact. Also, you're going to need their full name and their addresses. And then you're going to share powers that you're going to see it's listed A through N. I would suggest you pick all of them so they're not limited in any respect as far as powers go. You're going to pick if transfers are allowed or not. Transfers are a little tricky to explain, but the legislature didn't want people to get taken advantage of by their person because, as you could imagine, a power of attorney makes it easy for somebody to steal from you if they wanted to steal. And sometimes stealing means putting things into their name. The legislature also recognized that there are times where you want that to happen. So they picked a middle ground where they said, if you want your person to be able to transfer assets into their name or into the name of their children, you have to affirmatively say so on the document. And then also it's limited to the current tax gift amount. And right now it's $19,000. So that's the decision there. And then the next decision is what kind of safeguards you want to put in place. And that's called an accounting. An accounting is where they have to tell you what they've done for you and they have to do it in writing. And you can have them do it on a regular basis or when you ask it. We'll see it when we get to it. Then you sign it in front of a notary. Don't sign it until you're in front of a notary. Your attorney, in fact, does not have to sign in front of a notary. You sign that you initial that you read a notice about what this document is all about, and your people sign a notice that they've read a different notice about it. They're going to be reading about their fiduciary duty and what they can and can't do. So that's the basic stuff in a power of attorney. It's not complicated, but it's very powerful. Let's go to the next slide. So who would make a good candidate for your power of attorney? So think about who is there for you when you need them. For example, if you were sick, who's going to be calling you to see if you're okay? That person might be a good candidate. Think about if they're trustworthy, because like I said, a power of attorney can be a license to steal. So you don't want somebody who has any background where they've taken advantage of somebody. You might also want to think about whether they have any aspect of their life that might make it tempting having access to money. For example, do they have a lot of debt? Do they have a gambling problem? Those sorts of things. If so, maybe not have them as your power of attorney person. They might make a really good healthcare directive person. Sometimes my clients don't want to offend their children if they're naming their children as their people on different documents. So if sometimes people aren't best for one document, they might be good for another. Probably the most important is, are they willing? Are they willing to act as your power of attorney? And are they willing to do it in a reasonable way? Are they able to keep records? That sort of thing. They do not have to live near you. They can live in another state, in another country. Obviously, it's easier for them to act sometimes if they live closer to you, but they do not have. Almost everything is done electronically nowadays, so it's going to be okay to have them live elsewhere. Okay, let's go to the next slide. Okay, so we're about halfway through and we're doing fine on time. So now we actually get to see the document. This is a statutory short form power of attorney, and this one you can get from the Minnesota Department of Commerce. Anybody can. You can Google Minnesota Department of Commerce uniform conveyancing blanks power of attorney, or you can do form. It has a number on there. I can't read it with my eyesight on my screen. Can't remember if it's 10. I think it is. Anyway, anybody can get this form. It's free. You can also get this form from the Attorney General's office, I believe. You can get it through our legal aid coalition, minlawhelp.org. In fact, on our website for our coalition, they have a do-it-yourself power of attorney generator, which you log on to it, and then it asks you questions like your name and address, who you want to be your people, all that stuff. And then at the end, it prints out the completed power of attorney for you. So you wouldn't even have to handwrite this on or type this on to this form. You could have this form generated by that website. And it's private. Nobody can read your information. You can save it and come back to it. When you're done with it, they don't save it. So it's a safe way to do it as well. You can see on the top of this document, there's a big blank area. That's left blank in case it's used for recording of real estate later. So you don't do anything with that. So the first thing you do is you identify yourself as the principal on after the little title, statutory short form power of attorney, where it says principal. And then on the left, where it says attorneys in fact, names and address, that's where you put your attorneys in fact. I see Brenda says it's available on our community resources link at the Get Your Ducks in a Row website. So thank you, Brenda, for that. If you have more than one person as your attorney in fact, you can put them both here. You can put more than one here. If you have a successor attorney in fact that would act after your primary one, you put them on the right-hand side. Here you have the opportunity for 2 successors. If you have more than one primary attorney in fact, you can see on the bottom, you have to make a decision. Do you want them to act together jointly, or do you want them to act independently? So this decision can be a safeguard. If you have people that you don't quite trust, or you want them to keep each other honest, you can have them act jointly. But on the other hand, that's going to make it a lot more of a hassle for them to act, because they're going to have to communicate each time, and each of them will have to sign each thing that they do for you, which isn't necessarily bad, just something to keep in mind. If your primary attorney, in fact, can no longer act, your successor attorney, in fact, can step in. They would just complete an affidavit saying the primary can't act and give that to whoever they're acting for example, a bank. If they went to the bank, they would say, hey, the primary attorney, in fact, is no longer willing, or they passed away. I'm stepping in now. Don't get afraid of the term affidavit. It's just saying, I swear that these facts are true. The primary attorney, in fact, is no longer able to act on the successor. And then you sign that in front of a notary. Finally, on the bottom where it says expiration date, you want to put, I write none on mine when I draft them, because I want it to be clear that this has no expiration date, that I want it to continue until either it's revoked or the principal passes away. Alrighty, let's go to the next slide. Okay, so here we come to the two decisions there's about 5 decisions, and we already did one of them. So it's not going to take long to go through this document. So powers that you share, you can see that they're listed A through N right there. They're listed like that because people use this document for all kinds of reasons. Sometimes you use them for just a discrete thing that you want to do, one event, and you pick the corresponding power that corresponds to it. But for advanced planning, you want to have as many powers available to your person as possible. So it makes sense to check in all the powers listed A through M and above, and all other matters. And you can see that it says it does not cover healthcare decisions. So the legislature wanted to make it clear that this just covers financial and property matters and private information, not health care information. And healthcare decisions, just property and private information that's not health. So that's the first decision, which is pretty easy for advanced planning. The second decision is also going to be very easy for advanced planning, because most people want a power of attorney to be durable. And to do that, you want to check off the first line that says the power of attorney shall continue to be effective if I become incapacitated. So that's what makes it durable. You want that to happen, because if you can't act for yourself, you want your person to step in. So that's an easy decision. You want it to be durable. All right, let's go to the next slide. All right, so now we have 2 decisions before you sign as a principal. So on the top there where it says third, this is where they're talking about transfers to your person. Do you authorize your person to make transfers to themselves or somebody they have a duty to support? For example, your grandchildren. This is where the legislature wanted to build in some safeguards so people don't steal. So if you trust your person and you want them to have that ability, you check off the first line, or the second line, I'm sorry, I authorize, and then you put their name there. I authorize Jail Smith to be my attorney in fact, to make gifts to themselves or anyone the attorney in fact has a legal obligation to support. So this can be useful if, say, you have a practice of giving Christmas gifts to your grandchildren. If you were to become incapacitated and aren't able to do that anymore, your power of attorney could transfer money, so money or buy things for the grandchildren. Keep in mind, there is a limit of $19,000 per year per individual for the transfers. Sometimes people use it to transfer real estate, those sorts of things. If you don't want to do it, you check out the first line. I do not authorize transfers. I keep calling them transfers, but the form calls them gifts. The same thing. Sometimes anything that you're not getting fair value for. Was there a question about that, or should we save questions till later? What do you think, Brenda? Oh, I'll just
Whatever
answer.
you're more comfortable with. The question that came up was, who determines if someone is incapacitated and cannot make decisions for themselves? Can the attorney, in fact, do this themselves?
So the official answer is that it's only official incapacity if a court decides. So until then, it's an open question. If I was drafting a power of attorney for somebody to protect my license and my ethical obligations, I need to know if that person has a legal capacity to understand the document. So I'm going to try to suss that out myself by having conversations with my client. If I feel that they don't have enough to protect my license, that doesn't necessarily mean that they can't do one. It just means that I'm not going to draft it for them. I would counsel the client about how to do it themselves, how to have somebody help them do it in their family, take it in little bits of pieces at a time when they do have capacity. So it's not a cut and dry answer. I hope that answers the question. So the attorney, in fact, can help the principal draft it. They can draft it for the principal. The principal can draft it. Anybody can draft it as long as the principal understands the nature and effect of the document. And that's pretty low bar. Just means somebody stepping into my shoes to handle my finances. And then you take it a step at a time. Who do you want to step into your shoes? Then that decision, do you have capacity for that? And you go like that throughout the document until it's done. And if everybody is uncomfortable doing it, then perhaps the next step is for somebody to petition for conservatorship. But hopefully that wouldn't happen. Alrighty. So if you want to talk more about that, we can do that later as well. So that's the transfer decision. Is it okay with you or not? The last decision is, what sort of accountings do you want your attorney in fact to do for you? You can see that the first one here says, my attorney in fact need not render an accounting unless I request it, or the accounting is otherwise required by Minnesota law. And then the other one is, my attorney in fact must render an accounting on a monthly, quarterly, yearly basis, something like that. So this is another safeguard. So if you trust your attorney in fact, it's probably going to be less hassle for the person that you named for you to check out the first line where accountings when you request it, rather than having them on a regular basis. Because if your person might not use your power of attorney, say for 5 years down the road, and it would be kind of a pain for them to have to do it on a monthly basis, or maybe even on a yearly basis. This is all the things that I did for you, and they haven't done anything. So they would say, this is my accounting, I haven't acted for you. So if you trust your person, it's probably okay to choose the first one, where accountings are given when you ask for it. But either one is okay, because it's your document. Then finally, you sign it in front of a notary. You can see where the principal signs, and on the bottom there, the acknowledgement of the principal. That's all for the notary public to fill out and sign. And on the bottom is where their stamp goes. All right, let's go to the next slide. So this is where the attorney-in-fact signs. So your people sign two places. They sign on the first that they read this notice that's on the last page about what it is to be an attorney-in-fact. So they sign, no notarization is required for either of their signatures. So they sign that they've read this notice, and then they sign below where it calls for a specimen signature. Also, no notarization required. So you might ask, why do they have to do two signatures? Why not have one signature do both, be a specimen signature and certification that they read that notice? It's because this document came about in stages, and for years it just had the specimen signature. But then in the earlier 2000s, the legislature added this in as another safeguard. So that's why it's separate. And they didn't choose to alter the form to combine them. On the right-hand side where it says this instrument was drafted by, this is very important to fill out. Whoever filled in the form puts their name and address on there. This is called the draftsman's clause or the draftsperson's block. If you don't have this filled out, it cannot be used to record real estate. So it's important to have that filled out. And then on the bottom, this is the notice of the principal. If this is your document, you read this. It kind of goes over what we've talked about. Basically, you're not giving up any of your own authority. You're sharing it. Your people have a duty to act in your by your wishes. They have a fiduciary duty and all that. Let's go to the next slide. I see a question. I'll get to that in a second. So you can see this is where the principal puts their initials that they read that notice. And on the bottom is that notice that the attorney in fact read about what it is to be an attorney in fact. So let's see what the question is. All right. It says, it seems to me Brian was not asking about setting up the power of attorney as far as determining if the person was incapacitated, but after the power of attorney was in place, who decides that the person is incapacity and the attorney in fact needs to take over? That's a good question as well. And I apologize if I didn't catch it the first time. So when does this power of attorney get used? So technically, it's usable right away the moment the principal signs in front of a notary. There's no springing powers with this statutory short form power of attorney. It can be used right away. So if the principal finds out that the attorney in fact is using it when they don't want them to use it, then they should revoke it. But bottom line is it's usable right away. Sometimes the principal wants somebody to act for them even though they have capacity. Maybe they're on a trip or something. Financial matters taken care of. But it's more driven by the principal. So if the principal tells the attorney in fact to act, the attorney in fact can act. Because the power of attorney gives them the authority to act right away when the principal signed it. And I said it can act because the attorney in fact can always refuse to act. They can always stop wanting to do it. And then the successor can step in if there is one. So I guess I hope that answers the question. I see. Yeah, Brian says correct. My uncle does not seem capable of making competent, safe decisions on his own, so I'd like to exercise power of attorney to place him in a home. Oh, that's a really good question. I see a couple of things in that question. First one, I'm reading it to mean that the power of attorney is in place. So your uncle does not need to draft one right now because he might not have capacity to understand it. So I'm going to assume that he's already got one. Okay, good. Brian put in the chat that there's a power of attorney for his uncle. When Brian, you say to use the power of attorney to place him in a home, that exceeds the authority of the financial power of attorney. You wouldn't be able to use that to decide to put him in a nursing home. That would have to be a different legal document, such as a healthcare directive, because a healthcare directive can give powers of deciding where the person lives. But if you have that power to put him in a home, you could then use the financial power of attorney, this power of attorney, to sign documents for your uncle, to sign the admission agreement, for example. I'm hesitating. I have a little pet peeve about admission agreements for nursing homes. I don't think anybody should sign them except for the resident. And I think you can push back on it enough where power of attorney doesn't even have to sign it. But if you were to sign things, you can sign as a power of attorney for it. So I hope that answers the question. There's not authority from this document to put somebody into a different setting because that concerns their body. This only concerns their property, financial matters, and private information. Alrighty, thank you. And there is a healthcare directive webinar later on in the week that we can talk about that and more. Here's another chat question. I work at home health. I see many adult children or patients who believe they have power of attorney because they've signed something, quotes, at the hospital. Please touch on how that is not a power of attorney. Good question, Wendy. Typically what people sign in a hospital is probably going to be a healthcare directive, advanced directive, that sort of thing about your body, about your healthcare wishes, about what you want to happen when you pass away, that sort of thing. That's a totally different document. That's the one I was talking about in Brian's question with his uncle. That's the one that has the authority to decide where somebody lives, if it's in that document. Sometimes people limit the powers of the healthcare directive, so it's not in there. So you have to read the document. Right, that's a very good question. You always look at the document to see what it is, determine what authority you have with it, and that will guide what your next steps are. Let's go to the next slide. This is a practical slide, so I want people to know how to sign as an attorney in fact. So, for example, I'm my mom's power of attorney, so I want to know how to sign things so I don't become personally liable for things for myself. So to do that, I want to sign things to make it as clear as possible that I'm acting as her attorney in fact. And this is how you would do it. So this isn't mine, but this is John Doe as the principal. By his attorney in fact, Jill A. Smith. So in this example, Jill is the attorney in fact, acting for, let's say, her dad, who named her as his attorney in fact. So you can see the first person named is the principal. So that's the primary person doing the agreement or whatever it is you're signing. So John Doe, he's not signing, but by his attorney in fact, Jill A. Smith is signing for him. So that's how you should sign. It's okay if you do Johnny Doe by his POA, Jill A. Smith, but it's not as technically correct. Attorney in fact is the absolute correct term, but you'll get by with power of attorney. do not sign Jill A. Smith, because then you're making yourself personally liable. You always want to have the wording about your authority. And I put in there a little tip on the bottom. Beware that in some circumstances, the attorney in fact can be held personally responsible for the principal's nursing home bills, even if you're signing as the principal. This comes about if you misuse the principal's funds that should have been used to pay for nursing home care. So that's why I like to advise people who are acting as an attorney in fact not to sign admission agreements, because then you might have a little bit more argument. But there's other law that says, there's fiduciary law that says that if you're acting as attorney in fact for somebody and you're misusing the funds, then there's a way for the nursing home to come after you for that. So just be careful. That's why you want to keep records, keep it so you can give an accounting to your principal and anybody else to prove that you didn't misuse funds. A personal note from Cheryl. I was taught to never sign anything without getting a copy of it. Yes. Don't sign anything until you, number one, understand it. And two, you want to sign it. And if you sign it, you want to get a copy of it. So then you can refer to it later. All righty, let's go to the next slide. So how do you revoke it? Let's say that you don't want your attorney in fact to act anymore. The client, for example, whose attorney in fact stole his annual per capita check, and he didn't want that to happen again. So the first thing that we did was revoke that power of attorney. So this is what it looks like. It's basically just undoing the power of attorney. You sign it, I revoke and declare null and void this power of attorney that I did naming so-and-so. And they no longer have the power. So you sign it in front of a notary, and then you give it to your agent. To be complete revocation, you have to get it in that attorney in fact's hands. So if my mom were to revoke her power of attorney naming me, she has to do one of these, sign it in front of a notary and give it. So then there's actual notice to me. What would happen next if I was upset about that and worried about my mom, and I think she needs somebody to handle her finances? I could file for conservatorship to do that. And then there's the whole process of determining, does she lack capacity for them? And that's a bigger incapacity definition than the capacity that we're talking about for this document. Let's go to the next slide. What happens after power of attorney, after the principal dies? What happens to the power of attorney? It's automatically void when you die. There's no further authority for your attorney in fact to act. When that happens, if you wanted that person to be able to step in and handle your estate, then you should have a will naming them as your personal representative. If you don't have a will, at least have them as a co-owner on one bank account, so you could have somebody pay for the burial, that sort of thing. But again, there's risks for having co-owners on things because it's easy for them to take stuff. So that's what you think about. So power of attorney is an excellent document to have. Everybody should have one if they have a trusted person. Have more than one person if you have more than one trusted person. We can help you draft them if you qualify to be our client. We're going to have some workshops in the coming future that we can help people get them drafted as well. If you don't need an attorney, let's go to the next slide. I think we're at the end. Yep, just wanted to make sure. So you do not need an attorney. It's your document. Remember, nobody can tell you what to put on it. If you have certain things you want it to be, you have every right to have that on your document. Everybody has their own document. Married people don't share a document. And Brenda put a link to our community advanced planning workshops as part of the Get Your Ducks in a Row campaign that we're going to be holding in a lot of different places around the Northland. And Brenda, you can talk about our upcoming healthcare directive one, perhaps. And we do have a few minutes. We could do some questions.
It looks like Donna's got her hand up. Donna, did you have a question?
I do. On the very first page where the expiration date is on the bottom, you had said originally not to write anything in or alter the document, and it says use specific month, day, and year only. So should we write none in or should we leave it blank?
I write none. So when I was saying don't alter the document, it doesn't necessarily mean that you have to write in the information the way that they suggest on the form. What I mean about altering the document, I mean like adding another clause of something or crossing out an instruction and adding something in that instruction in that clause itself. But just the fact of using the word none doesn't change the statutory form of it. That's a good question.
Thank you.
Mm-hmm.
Anyone else have any? Oh, good.
Oh, sorry. I'm just gonna say it's better to put something in there than leave it blank, in my opinion, because then there's no question about the expiration of it.
All right. Does anyone else have any other questions? You can just take, if you have a question, you can just take yourself off mute, or if you feel more comfortable, you can put that in the chat. We've got just a couple moments left. In the meantime, I have put in the chat the link to the community workshops that we're going to be taking place over the next 6 months. So you can take a look at those. Also, information about the rest of the webinars this week and the link to be able to register for those. It looks like Bruce had a question about, can the principal withhold the power of attorney to a future date?
So yes, Bruce, that sometimes we refer to those as pocket documents because people hold them into their pocket until they want to use them in the future. You can do that. It might not be the best situation because when the time comes for your people to use it, they might not have the document. They might not know where to find it. If you trust your person, I think it's better to tell them and give them a copy well before they need to do it. And keep your power of attorney in your important documents at home, your copy of it. And then where can I get these documents? You can get them on that link above that Brenda had put in the chat. You can go to the Minnesota Department of Commerce and get it from their uniform conveyancing link webpage. You can get them from Minnesota Law Help min.org. I always mess that up. Just do lawhelpmin.org, Minnesota. You'll find it. You could have, Bruce says, or have an attorney hold on to the document. You can, but your attorney might go out of business. Something might fall through the cracks. It's something to talk to about to that attorney. I would feel a little bit, I would worry about having that, safeguarding that in my files for somebody, but it's possible. Alrighty. Could we go back to page 4 of the short form? There was something I didn't understand on the bottom of the page. Sure. Let's do that. And if people don't want to stick around, you don't feel like you're obligated, but I'm happy to answer any questions. Let's see. Here's page 4. What is the question? It's the notice to the principal. So this is what the legislature wants each principal to, the bottom you just read as the principal, so you understand the document more. The top of the page, I did not understand the two different signatures. Sure, I probably went too much into it. But anyway, all this means is that the first signature where it says notarization not required, that's an acknowledgement that the attorney in fact read that notice that's on page 5. So it's just a way that the legislature wanted to make sure to slow down people so that they actually read more about this document so they can understand what their duties are, so they can agree to what it is. So they would sign that they read it. And then the second signature is just an example of their signature. They call it a specimen signature. It's just another example. It's a holdover from prior format of this form. But they have to sign both of them still. Hope that answers your question, Kathleen. Mary asked.
We had a question from Mary about, and a couple questions from folks about recordings of this, and they will be, you'll get a link for the recording when we have it ready. We'll go out via email to everyone who registered. Otherwise, they can go on to the Ducks campaign website, which we provided some links for in the chat, and those will be posted later this week.
And Mary's question about why she couldn't hear it, hopefully, I don't know the answer to that, Mary, but hopefully when you get the recording of it later, you could hear it when you play it back. So I apologize that you had that problem during the presentation. Does the principal sign under this agreement was drafted by? No. Kathleen, that's where whoever filled it in would sign, and it's not necessarily the principal that's filling in the document. So whoever fills in the power of attorney document fills in that block drafted by.
All right. Well, thank you so much, Kristin, for being with us today and for sharing all of your knowledge and your expertise. And again, we will have the recordings for this posted, and we'll get a link out to everyone. You've got if you're interested in the healthcare directive webinar or we've got one on end of life planning and one on effective conversations on advanced care planning. How do you have those conversations with friends and family coming up this week? And those can all be found, information about those and registration can all be found on the Ducks website. And I will put that back on here so that folks can check those out. Thank you so much, and everyone have a wonderful day.
Thank you all.
Thank you.